we'll see what we can do. That was what the first thing I was going to say. This meeting will be recorded for training purposes, so I just want to make everybody aware of that. Also, if you have questions throughout this, please feel free to put your questions in the chat box during, and they may have the opportunity to look there and answer them throughout, or we'll certainly have a Q&A time at the end if you want to unmute at the end and ask your questions at that time. That works as well. Again, also, I'm going to try to put in the chat box. If not, we'll try to get your emails and get this out to you, the bio on both of these folks, because they have pretty impressive credentials, but it will be here all day if we go through them all.
Hey, you're dating us.
I was going to say that. I've been friends and known Steve for many, many decades. He's worked hand in hand with us at both the previous broker side of MAMP and then the MMBBA. And has facilitated a lot of educational meetings. He represents a lot of our members, along with a lot of other things. So today we have Steve Lovejoy and Rachel Wolf of Shoemaker & Williams, and they are here today to help you with some of your auditing questions for the Maryland audit. I'm sure they're welcoming any other kind of some similar questions in that arena. I have found personally with my broker community and lender community that the auditing has been specifically, it's always difficult, but it seems to be a little bit more difficult this year for everybody, a lot more challenges to get over. So we're going to let them give you hopefully some helpful tips to get you prepared and also get through that without too much pain and suffering, and also not hitting your pocketbook too much. So I'll leave also their information, contact information in the chat. So if you need to contact them directly, please feel free to do so. But without further ado, I'll let them get started on today's auditing seminar.
Well, hi, good morning, everybody. It's nice to see everyone. I just flew in from outer space and boy, are my arms tired, me and Jeff. I also used to do seminars for the Mortgage Bankers Association before the merger. Going back to the early 90s. And so we've got considerable experience, not only representing people, but also doing these types of seminars and things. It's been a long time. The 2-minute commercial for the firm. We're a full service business firm. We do everything from the corporate stuff to litigation to, we have a very robust human resources. So if you have issues with human resources, particularly and the overlay of the mortgage rules, like the LO comp rule, things like that, we do that every single day. So if you have issues, come to us. And if we don't do it, which we do just about everything for business, we know someone who does. The other thing is that we are not limited to Maryland. We're admitted in a bunch of states on the East Coast. But even throughout the country, most of the time, if you're dealing with the agency, unless you have a hearing or something, the agencies do not mind attorneys that are not admitted in their state working on issues that come up. We had 12 cases in Washington State 2 years ago. So, we're kind of all over the place. So there's your 2-minute. And Rachel has done a lot especially with exam responses and helping people shepherd through exams and helping people prepare for the exam. Okay. And that's really your cheapest cost, is to think about what you need to do beforehand and try and set things up so that you're not going to have huge problems when the examiners knock on your door. They've changed it to a 5-year cycle now, and we'll talk about what that means. But there's been a significant shift towards requiring policies and procedures, written policies and procedures. And Rachel has been working with many of our clients on that score, and she's going to hold forth on the policies and procedures that you need and how to, how to configure them. Okay. Here you go. Here,
Sure,
let's switch.
Sorry about our technical difficulties. Before I start talking about the policies and procedures, I also just want to mention that the state has been, I don't know if it's still in pilot, but I would say that at the beginning of this year, the end of 2020, they started using the state examination system, which is CSBS's online system. So if you're in other states, you may have already used the system, but for Maryland, this is a first. I've seen the brokers using this system first. I don't know if they rolled it out to lenders, but it's, you know, it's a different experience than you've had in the past where you would get this like 25-page exam questionnaire. Now everything is online. So you'll receive you know, a notification that the examination is starting, and then you'll receive information regarding how to enroll in the SES system. And I've heard from one of our clients that it involves downloading an app, and you'll you know, have to enter some type of security credentials to log in each time, but it's very secure. And, you know, once you're up and running, it's very easy to navigate, more easier to navigate, I think, than NMLS even. And with this new system, you'll see a lot more robust requests for information. The SES system has just, you know, it's a system that's designed to be easier for regulators to assign the information requests in question. So you would log in and you would see, you know, your first round of information requests, you're going to see, you know, over 100 questions that it may or may not even apply to your business. And then you'll have to provide a response for each individual numbered question, and or just a request for information. So it's a lot of work, and you have to be prepared to check back in, make sure you know the deadlines for the different information requests, and check back in, because then there'll be follow-up requests. And that's sorry,
That's all right.
So another thing that we've noticed, in addition to what Steve said about more policies and procedures, the timeliness of your response really can play in. So if you, it can be very overwhelming. And if you dawdle, they'll sort of take it as you're not being responsive. And we've had clients be fined. One client just was fined $1,000 just for being slow to respond. If you're overwhelmed, communicate with your contact at the state, ask for more time, let them know that, you know, you're working on it. Just, you know, work with them. Don't just sort of put it on the back burner because you've got business to deal with.
I have a question for you, Rachel. Does this work like? Does this work like NMLS in that if you're in multiple states, the information that would be the same from state to state, like your financials and stuff, that once you input it, that all the states can get it?
I actually was wondering the same thing, and I looked into that, and it seems like, you know, in the same way that now you know, your examination reports are confidential, the state can request from another regulatory agency, another state, if they can have access to that information. And I don't think that, you know, another state would have any reason not to provide the information, but I don't think it's like the same as NMLS at this point, where if you uploaded a policy, then other states could see that policy.
Okay.
So
well, you keep that in mind. So.
But I'm really not sure about that, and it might just be that you just have to open up something to give access to another state. So let's see. it's a lot of work. It's daunting in terms of the policies and procedures that they're asking for now, because they're kind of slicing and dicing and asking questions that, you know, the answer may be already in a written policy that you have. So it just may be confusing because they'll break it down into smaller questions. So they'll have one information request will sound like here's one: provide the company's written compliance management program, all policies and procedures and manuals related to all products and services offered by the company to comply with state and federal laws, including any alternative or supplementary guidance like your desk manuals or your system support manuals, anything for compliance. So that's a pretty broad request. But then later on, they'll go into specific requests for, you know, your advertising policy, your record retention, your vendor management. They'll have specific questions for employee issues. They'll ask for the employee handbook for policies and procedures related to hiring and departure and pre-employment screening and so forth. And if you have an employee handbook, this is probably already all going to be in there. And then, of course, policies and procedures related to employee compensation, the plans and any bonuses and incentive programs. They'll ask for specific information about training. They'll want the schedules, the records of completion for compliance training for, you know, board, for compliance staff, and then for employees. And they'll want to see, they'll ask specific questions about the board and senior management, because that goes to the issue of board oversight, which would be, you know, in your compliance management program. And they'll ask questions specifically about that. What's boards, how is the board and management involved in developing and policies and procedures and reviewing policies and procedures? You know, what's the level of oversight there? You know, tracking and monitoring exceptions. How does, you know, what's the review process for policies and procedures related to mortgage activities, and questions regarding change management. You know, how do you make sure that your policies and procedures are up to date when there's changes in the regulatory landscape and for other reasons? They'll ask for, you know, your audit, any audit reports, any QC reports, your procedures for audit and QC. They'll ask about your compliance software. They'll ask about risk assessments. A big area that you need to have, which I believe they've asked for in the past, so it shouldn't be new, is the BSA, AML, OFAC, you know, fraud. They'll want to see your written program. They want to see procedures. They want to see your AML risk assessments, and your they'll ask for tests, the results or reports from your independent testing for the last 2 years. And if you're in a lot of states, you've seen some of this stuff before. You know that you have to be careful about what you provide when they ask for any type of audit report, because they'll, you know, you might get a report that raises some concerns, and they'll sort of seize on that. And then they'll also want training documentation, including board training, financial privacy and information security, identity theft. You should have your red flag policy. You should have your written information security program. Maryland in 2019, in Comar, they have their new data protection regulations all laid out, you know, similar to some of the other states. So now they're, I think all the states are looking deeper into financial privacy and security. They will do a deep dive, and they'll ask for, you know, what is your data backup? What are your email policies? What's your clean desk policy? Do you have any virus protection? You know, every little itty bitty sort of procedure that could go into your information security program. And in addition, they'll also ask specific questions about record retention. And they'll ask if you have approval for electronic storage. And I don't know if you're aware, but now there's a form on the commissioner's website, and that once you fill it out and put it in NMLS, that serves as your approval under COMAR.
I don't have to wait for it, right?
Yeah, for electronic storage. But and during the exam, I think they give you the opportunity, if you haven't addressed that yet, to go and fill out the form and upload it to NMLS. And once you upload it, then you would provide that as your response.
And on information security, let me just say this. We just got word from a relatively small title company that they got hit with ransomware. So if you think you're too small or too isolated or not important enough that these guys won't go after you, think again, because they're doing it. And they're having a real problem. The Land Title Association says that quite a few of them got hacked. So it's happening out there.
It is. So, but hopefully, by now everybody has good, security and virus protection and all of that stuff. The Maryland regulation actually says that that a licensee needs to have an information security risk assessment at least once every 3 years. And it doesn't really specify what that involves. So, that's up to you. And I don't, maybe they'll put out more guidance on that, like some of the other states have. But it is something, to think about if they did request your latest information security risk assessment, what could you give? Just, with all these policies and procedures are that they're requesting, I will say that I haven't, with the clients that have been using the SES and these types of questions have come up, I haven't seen any concerns raised about policies and procedures. And I had one client that said, we're working on this, it's in process, and they didn't raise any issues about that. So, in general, you should have all the policies and procedures already for the CFPB laws and regulations.
And if you're a broker, can you get some of this from the lenders? I mean, that you're sending loans to, because they will have more extensive policies and procedures than maybe a broker might have.
You can pirate some stuff, but you want to be careful not to have, as a broker, policies and procedures where you say that you're doing one thing or another that you're not really doing. It's better to, I think if you can satisfy a state regulator by giving a description of your policies and procedures rather than giving your whole, book, I think that's better, because I think we all, sort of fall into the trap where we buy some policies and procedures that aren't tailored, to our business. And then we might say that we're actually, auditing or providing training or whatever it is on a schedule that we're not really following. So sometimes less is more, as long as it's accurate and it covers all the bases. But if you have any questions about that, we would be happy to answer. Like I said, in the state's response to the exam, so far, I haven't seen them raise any issues regarding policies and procedures being missing or inadequate. It still seems that the meat of the exam is really the loan file review. And as far as that, you'll send in your spreadsheets. There's I saw one request for a spreadsheet that had about 50 data markers that they were looking for. I don't know exactly how many of them they're looking at, but that's what they've requested. And then you'll get your request to upload your files, and you may get follow-up requests after they take an initial look at that. They might want to request all your notes in your correspondence that you wouldn't normally have in a loan file that you would give for an exam. So that might be something new that you would see for Maryland. But again, it's going to come down to checking your compliance by reviewing the files, and Steve is going to talk about
And I'm going to
that.
talk about that.
Yeah.
And we're going to start, yeah, you want to switch back?
Yeah.
Okay, we're going to start with the questions, Amanda sent me some questions that people had posed initially, and they lead into explaining some things to you that you need to keep in mind. The first question is, do brokers need to have a signed commitment letter in every file? If not, when did DLLR stop requiring the commitment letter? The answer to that question is June 30th, 2017 is when they stopped requiring that in loans that are compliant with TRID, okay? That doesn't necessarily mean they have to be a QM, but they have to be, TRID has to apply. And the only thing that we know that most of our guys, some of our clients are doing that TRID doesn't apply to is revolving credit. And that includes the revolving HECM, home equity conversion loans or reverse mortgages that TRID does not apply to. So the financing agreement, the commitment requirement arose because in the late 80s, they put in the law that requires a financing agreement. The financing agreement was intended to tell the borrower whether or not the loan was locked in, whether the loan terms were set in stone or not. And if not, then 72 hours before closing, you're supposed to provide a commitment. And that's where the commitment requirement came from. So June 30th, or actually July 1st, 2017, after that, if your loan is after that, then you do not need to have a financing agreement or a commitment. Those, in my way of thinking, were lender documents more so than broker documents, but the commissioner's office interprets the word licensee in the statute as meaning brokers and lenders. So there you go. All right, the next question is, does each closed loan require a transmittal form 1008 and a final 1003 in each file? The original 1003 is in the file from the initial mortgage application. We have never seen anyone require a copy of a 1008 transmittal in the file as part of the exam experience. 1003, you don't necessarily have to have the final, but if you have access to the final, that is, if the closing file comes your way, then you'll want to keep that. They use the application to determine the point at which they start counting the 3 days for the federal disclosures and the 10 days for the broker agreement if you're brokering. So it's important to have to maintain the application, have the application, but I'm not seeing them require the final as the final typed version, as long as you didn't have a copy of that. So you don't have to go, beating on the lender to send you, or the title company to send you the closing file necessarily. It's nice if you have it, and you should keep it if you do. Next, for credit reimbursement, do you need a copy of your canceled check to the credit bureau showing payment of this bill in each file? How about other reimbursements such as condo certs and appraisals? Okay, pass-throughs. Let me just say that the invoice is probably the best. That's usually what they look to, and not so much the canceled checks. Canceled checks help if you have them, but the important thing is that the CD, okay, the closing disclosure, itemizes those things, and they should be the same dollar figure that you collected from the borrower. And if you overcharged them in any way, then you should, on your own, have a post-closing method for identifying those loans and sending the borrower a refund check of some sort, okay? And maintain that. And if you do that in advance, you get extra points when they examine you, because they'll say, oh, look at this, you know, you owe this person. You say, well, we already identified that and we made the refund, and that helps you with the exam. Lastly, what laws were passed in the Maryland legislature in 2021 that affect mortgage brokers? What past laws were vetoed in 2021 that will be overridden? The only successful piece of legislation of which we are aware that affects the mortgage industry that passed in 2021, or that then, you know, was there aren't any vetoes that I'm aware of that affect us, is the one that the commissioner put in to eliminate paper licenses. Remember, you had to get the paper license and post it. Well, you no longer have to do that. So yeah, thankfully, you know, I've been in many offices where you got the wall is covered with them, because you got, not only you got the company licenses, but you got all the MLO licenses too posted. So you know, sometimes that's a good advertising thing to do, but you're not required to do it anymore. Last year, there was a significant bill that affected reverse mortgages in Maryland. And so if you're doing reverse mortgages, you might want to go back and take a look at that bill that passed. You know, frankly, I forget what the number is, but I'll send the number to Amanda so she could post it on the association's website. Okay, those are the questions, the preliminary questions that we had. Let me talk about the focus here, because despite the focus on policies and procedures, which really came from the CFPB originally, they were the ones who said it's more important to have policies and procedures than to do things right. I mean, it's a little bit like new math. Getting the answer isn't the answer, it's understanding the process. So if you can show that you understand the process, the CFPB is happy with you, even if you've got some warts. But Maryland and most of the states are still focused, as Rachel said, on the review of the files themselves. And to that end, let me go back to the commercial for the law firm. We have George Kinzel, who's not a lawyer, but spent 33 years with the commissioner's office, and he ran the exam. He was the head of the examination section. George, for a reduced fee of $100 per loan file, will go through loan files for you and point out things that the examiners are likely to write up and say this is a violation, and so that you can sort of understand and get a handle on it before the examiners come in. And that's been a very valuable, you know, service, I think, for those who have availed themselves of it. Because you're a member of the association, you get a special rate of $100. It's normally $150 if you're not. So we keep George busy with that, and that's real worthwhile. Lenders and brokers, they're looking for the net on refis. They're looking for the net tangible benefit form. The state put out a form. If the state puts out a form, use the form. Hey, you know, creating your own or having a lender give you something that is different is probably not a good idea. And even though the net tangible benefit is in many viewpoints more of a lender thing than a broker thing, they look for it in broker files. So you have to have that, and it has to be signed by the borrower. So be aware of that. The form is available if you don't have it on the commissioner's website. Okay, we talked a little bit about third-party fees. You need the documentation for the third-party fees that you collect and the fact that you have dispersed. That's important. Another thing you need is if there is a change of circumstance, under TRID, if certain events occur that say, well, this loan that we originally thought we could make for you, give to you, isn't going to work for one reason or another. And there's a laundry list of items under TRID that allow you to do a change circumstance, but there has to be a change circumstance disclosure to the borrower, and you should say, and you have to keep a copy of that, what you provided. And that's true for brokers as well as lenders. Also, there's an ECOA requirement, Equal Credit Opportunity Act requirement of providing a copy of the appraisal to the borrower. And a copy of the appraisal needs to be provided to the borrower within certain timeframes. I think it's 3 days prior to closing. Most lenders get that waived. And so you'll want to try to have a copy of the waiver in the file, because for whatever reason, that's one of the things the examiners seem to want to look at. It's not a very meaningful thing from my perspective, but hey, that just points out the difference between the industry's sort of perspective on things versus the regulators. They will nitpick in areas where you say, well, what difference could it possibly make whether I give them the appraisal 3 days before or at closing? What, come on. But the examiners are, the rule is the rule. And depending on who you get, that's what you have to deal with. So another issue is unlicensed MLOs. We say, oh, we don't have a real problem with that. Well, you shouldn't. But where this comes into play is in two areas. One, if you have any branch offices and you have a branch manager, and this branch manager is going to get a portion of the profits of the branch. Well, they can't do that if they are a producing branch manager, meaning they do loans. And what is it that triggers them doing loans? Well, if I have always said, if you are a branch manager and you want to maintain being a non-producing branch manager, don't talk to consumers at all. Because the minute the consumer calls that branch manager and complains and says, my loan officer told me he was going to pay for the appraisal and now they're trying to charge me for the appraisal. And the branch manager at that point is negotiating loan terms. And the two things that you cannot do without an MLO license is take an application and negotiate loan terms. Now, can you take some financial information? Yes. You can take some financial information. Can you quote the current rates? Yes. Can you provide them with a sheet that quotes the current rates? Yes. Without a license, that's fine. But once you start interfacing with that borrower, once you start talking about those numbers, and once you start, getting financial information about the borrower, you've crossed the line. Another area where this comes in and has come in quite frequently actually in the past, and that is where you have trainees who are trying to get their MLO license. They're in the process, they're taking the courses. There's no reason why they shouldn't, make it, they qualify. They're smart enough to be able to pass the test, et cetera. But, they need to earn money while this process goes on. And they're saying to you, well, I can generate business for you. Can I get paid? The answer is, yeah, they can, but you got to be very, very careful. They need to hand off to a licensed loan officer the minute they start accepting information about an application, and the minute they start saying to the borrower, well, you know, we've got here are the loan terms. If you can raise your credit score a little bit, we can probably do better on the rate for you. Once they start doing things like that, then they are crossed the line, and they would need a license. So they can't do that stuff. So you got to ride herd on the younger people or the early people who just started, who haven't gotten their license yet. That's important. And the commissioner's office has come down really hard on people about that and fined them a whole lot of money for unlicensed activity. They just don't tolerate that. It's very important. Unlicensed locations. Well, that's a gray area. That's a gray area. Things have gotten even murkier in the light of COVID, because most states, and Maryland is one, have said it's okay for the MLOs to work from home. You cannot, you have to be assigned to a licensed location. So you can't have someone in Colorado who has no access to your Maryland office at all, not have a licensed location that they can go to. You need to license their home office even if necessary. But if your MLO is working from home, which many still are, and the home is not used, the address is not used for mailing, it's not open to the public, they never see anyone at their physically in their home office, a customer, then you're going to be okay until further notice, because with COVID, most states have really relaxed that. Some have published formal stuff. Some have just said, no, you can do it without publishing anything formal. But we're in reasonably good shape there. Once you have a location that you really regularly use, other than working from home, you really should get it licensed. It's cheap insurance, believe me. And the wholesalers, if they get wind that you're operating out of an unlicensed location, you got a problem. If you're a lender, okay, and you're doing FHA, and FHA gets wind that you're doing FHA loans out of an unapproved, unlicensed location, they will yank your FHA approval. I've seen that happen several times. Okay, unlicensed location. Pre-printed signatures on broker agreements and things like that are not kosher. You need electronic is okay, DocuSign is okay, but you can't pre-print the name. You've got to sign it. And as we know, broker agreements, financing agreements, if they're required, which as I said before, it's only on revolving credit are they now required. The broker or the lender has to sign, depending on who it is, who the licensee is, who's issuing it. And DocuSign is okay again, but and authorized MLO is okay. That's fine. Have the MLO sign the thing. That's perfectly okay. But pre-printed signature, Maryland does not go along with it. Maryland does not allow an inspection fee, and they look for this in the exams. Most of the time, it's servicers, those who have servicing rights, that get into inspection fees, but occasionally we see one where, the appraisal was 3 weeks ago. You had bad weather and you want to go check and make sure the house is still standing, that no tree fell into it. Sometimes lenders, require that. And that can't be charged for. Normally, that's a lender function, not so much brokers. But just to make you aware that that is the case. That's a statutory thing. You can't charge for an inspection fee. Certainly you can charge for an appraisal, and if more than one appraisal is required because of circumstances, it's okay to charge for both of them. Of course, that's a pass-through, and you can't pad and keep any portion of that. The broker agreement continues to be the largest area where people have problems with inadequate broker agreements. The commissioner's office has put out 3 advisories that are available online. If you go to the commissioner's website, go to industry advisories is a separate category. You click on that and you will find them. The first one is August 5th, 2005, and it's titled Mortgage Brokers. It talks about the finance, it talks about the broker agreement. The broker agreement, ladies and gentlemen, is a contract. It is not a disclosure. Okay, that's it was originally it was a part of the statute was enacted. It's called the finder's fee law. It's in the commercial law article. It was enacted in 1979. In 1979, a mortgage broker was somebody you went to if you couldn't get a bank loan. You went to the broker and you said, the banks turned me down, the savings loan turned me down. And the broker would say, I'll find you a lender. And they would go and find usually a private lender. And they would say, here's your lender, sayonara, 8%, please. And that was basically all that brokers did back then in those days. And that has changed, obviously, dramatically. But what you have to realize is that this is a contract. And the contract says, I'm going to find you a loan, basically. And here's what you're going to pay me for it. So the amount of the fee, whether it is a percentage of the loan amount, which works fine, or a dollar figure, has got to be specific. You cannot use terms like up to a certain amount. You cannot say, here's the range. It must be specific. And believe me, what they try to do, and what they have done it to some people in the past, is if it says something like that, even if what you collected at closing is within the range or is under the cap that you talked about, they're going to make you refund the entire amount. And they'll remind you that they can require you to refund up to 3 times the amount based on the statute. So this is something that really bears careful scrutiny to make sure you're on the right side of that one. From X to X, it's from 2 to 3 points. It's easier now because what with the LO comp rule, most lenders, in lender paid transactions at least, you're being paid the same amount. So only if you hop from lender to lender, and there's a difference in what that lender will compensate you at, do you have a problem. But bear in mind that it's a contract, and once you've signed the contract, there has to be a real good reason to not honor that contract and honor that price. And market moves and things like that don't count. That's not a valid reason for raising what it is you're charging the borrower. Okay, it must be signed by both the borrower and the lender, and it's supposed to be signed completely within 10 days. Now, it's a little hard to do that. You got to provide it within 10 days, and it's always going to be signed by the broker, okay? But, getting the copy back from the borrower is sometimes a little difficult. If you're doing things electronically, it's a little bit easier, frankly, because, you could DocuSign and you could say to them, we need a DocuSign, let's go. That works well, and you can get it back within the 10 days then usually. All right, the next advisory that the Maryland Commissioner's Office put out on this was on March 1st, 2021. No, I'm sorry, February 16th, 2018. This, for the first time, said lender paid compensation is considered a finder's fee. Prior to that, that was not the case. And that impacted on what we fondly used to call the 24-month rule, which restricts the compensation that you can get as a broker between if a loan is secured by the same property within a 24-month period, 2 loans. There's still a restriction, but it's on the amount, but it's well below what one would think based on federal law you're going to be charging anyway. So 2018 is when that rule was very clear. The commissioner's office sort of sent a notice to everybody that here's the way we're going to look at this from now on. So that's the way you have to look at it as well. The third one is the Maryland Mortgage Broker Agreement, March 1st, 2021. This one arose because quite a few of our clients and the commissioner's licensees who were brokers were utilizing broker agreements that the lender was requiring. And the lender's broker agreements did not always comply with the rules that made it a contract. It looked more like a disclosure. There was language in there that sort of, made things wishy-washy as to whether this was a committed broker fee amount, this kind of thing. And the commissioner's office then started to come down on people, and they said, well, wait a minute, the lender is requiring me to use their form. And to that, the commissioner's office said, well, yeah, okay, we get that. But we want to, if you tell us that they're requiring this and it doesn't comply, you're responsible, period, if it doesn't comply with the rules. So you need to tell us if a lender is requiring something which does not comply, and then we'll go to the lender and we'll talk to them about it. That's what was happening. As a practical matter, if the lender is requiring a document and you don't think it complies with with the law or with what you are providing, then you should provide your own broker agreement. Okay. The commissioner's office doesn't like to see 2 separate agreements in the loan file. So if this is the circumstance, you got a lender who insists on your using their form, you don't like their form doesn't appear to comply with the law. And oh, by the way, if you want to make sure it does, that's one service we certainly provide very quickly. We can look at it and tell you if it complies. We also have our own prototype broker agreement that we have out there, and we periodically change to comply with any changes in the law. So the recommendation is that if you have 2, you've got one that the lender requires, you've got the one that you are supplying because you want to make sure you're within the law, you mark the one that the lender requires, lender required document, or words to that effect. And that should telegraph to the examiner that, yeah, we provided this agreement, but the broker agreement that we are honoring is the one that we provided. It's difficult if there's a discrepancy in the amount of the broker fee with those. That also raises red flags. So you have to negotiate that a little bit with the lender, and hopefully the lenders are starting to figure out that if they're going to require something, it better comport with the local law. The problem with the larger lenders is sometimes they're real good on federal law. Boy, they know what they're doing, no question about it. But from state to state to state, sometimes there are things that get missed. And particularly in a state as quirky as Maryland is sometimes. So go back and read those 3 advisories. They're very instructive. They're a lot of what I've been talking about so far. I think I'll stop there. We've got about 6 minutes left. If people have any questions, did anybody send in a question?
Yep, Steve, actually, I just, Ginger, if you want to unmute, I see that you've got a couple questions here, and then Aaron Donnelly also has a question.
Okay. Ginger,
Yeah, hi, how are you doing?
you're great.
Is an appraisal disclosure required pursuant to Maryland Code, Real Property Code 14-104-1, as long as you're following the federal regulations?
Yep. Yes.
It is, okay.
Yes.
And then I do have some more specific disclosure questions. Is the Maryland specific housing counseling disclosure required if the federal disclosure is provided?
No.
Okay, perfect.
No, the federal word, that is actually a regulation of the HCD, the Housing and Community Development Agency, not the Commissioner's Office. For a while there, the Commissioner's Office wasn't checking for that, but if the federal, they've actually announced that if the federal disclosure, if you do the federal disclosure, that suffices for Maryland.
Okay, perfect. And then is a lock-in agreement required to be provided? I know there's no promulgated form.
Well, the lock-in agreement, if you will, is the old financing agreement. Okay. And Maryland doesn't require that anymore in loans where you have an LE and a CD. And TRID applies. It still applies to a first lien transaction that is revolving credit. So if you have a HELOC that's not a second mortgage, it's first mortgage, there's no first mortgage. Or if you have a HECM, all right, which is a revolving HECM, which is what most of them are now. They don't do that many closed-end HECMs. Then the financing agreement continues to apply, and for all intents and purposes, that is a lock-in agreement because it says whether or not the loan is locked in. That's the point of a lock-in agreement.
Okay.
Other states do require
Yes.
a lock-in agreement. I mean, okay, so Maryland is not, in line with that. New Jersey requires a lock-in agreement. I think Virginia has some rules on that as well. So. Okay.
And then last question, is the signed acknowledgement of the receipt of a copy of the note required as evidence that copies have been provided per Maryland law?
That is not required under Maryland law, but the title companies and the wholesalers are going to require that. They want to see that.
Okay.
So it's an overlay, but it might as well be a law. It's not a law, though.
Okay.
Okay.
All right. Thank you so much.
Sure. Now, who else had the question? Amanda?
Aaron?
Aaron.
You might have to unmute Aaron Donnelly.
I actually don't have a question. It was just a comment about how
Sure.
frustrating the states are that if they would just provide disclosures for us, whether it's a broker or lender, would be, really a novel idea.
Yeah, well, I mean, they do have, for example, the net tangible benefit form, once in a while they come up with that. But you see, the thing about the broker agreement, for example, okay, they don't provide a prototype broker agreement. And the reason for that is the broker agreement is really does more than what the statute requires or should, okay? What it does is it establishes that the borrower has to, ours does anyway, establishes that the borrower has to cooperate and provide documents and things. And if they don't do that, then, this agreement is going to be, void. It also has disclosures in there that say clearly that you're not acting as a lender. It has disclosures that are intended to for for plaintiff's attorney, okay? If the borrower gets disgruntled at some point and wants to go to an attorney and sue you, or go to the regulators and sue you, this is intended to show that you fully disclosed everything that was going to happen and how it was going to work and what you were going to do. It also, it helps with RESPA, because at some, you know, particularly back in the 90s, although there's some resurgence of this, a broker can't just get paid for a referral. You have to do something. Well, what is it the broker's going to do? Well, here are the things, here are the services that we provide, here are the things that we do. These are the core things that brokers do now. You know, the old finder's fee example I gave you wouldn't work with RESPA, where you just refer somebody to a lender and then you get paid to do that. That doesn't work anymore. So the broker agreement means a lot, and because it's a contract, it carries a lot of weight, and the commissioner's office, you know, feels like they don't want to intrude in that area. So, okay, well, I guess we're at 11. So Colleen, Amanda?
You got one last quick question. We'll close it out after that. I'm not sure who this is. It's SMBIF. The question is regarding the
I'm
broker.
Sandy Marshall.
Okay.
Hey, Colleen.
Hi, Sandy.
Hi. Just had a quick question about the broker agreement.
Sure.
Can you just, you know, like if my comp is set at 2.5, and then, you know, for whatever reason, I actually make less, can I just list 2.5? As long as it's less, it's okay, or it has to be the exact amount?
Well, let me say this. If it has never been the source of a fine or anything like that when you have disclosed more than you actuly receive. Okay, because I mean, nobody's hurt by that.
Right. Yeah.
You got to watch that though, because you know, I had one client who said, "Oh, well, then I'll just put 8% in every file, every broker agreement, and as long as I collect less than that, you know, it's okay."
Right.
No, that's not okay. They will go after that sort of thing. So.
Right.
You need to be reasonable about it. If you have an explanation for why you collected less in the final analysis, that's helpful. But they generally speaking won't write that up.
Okay. Very helpful. Thank you.
Sure.
All right, everyone. We had a good group here today. Hopefully you got some helpful hints. If you need information, I did put their bio as well as their contact information in the chat. If you need any other information or ways to get in touch with these folks, please let Amanda or myself know. And again, while if you are in the middle of your audit and need assistance, or frankly, anytime and have a question, please reach out to either one of these folks. And lastly, my last pitch will obviously be for MMBVA. So if you're on here and you're not a member, please consider reaching out to us. We need your support. We also need your voice. Somebody mentioned having, you know, the state keep documents that we need for our files, as well as some other things. We've been asked that as well. Why doesn't MMBBA do that? We frankly just don't have the resources to keep up with it. It's so ever changing. We've tried to do it in previous years, and it's just too much. So we need all your support. So if you're not part of the association, please consider participating, joining. And if you want to be any part of the board or membership, I run the membership committee, but there's many others. So if there's something that interests you, reach out and we'll certainly point you in the right direction. Thank you all. And
thanks, everybody.
Hope everybody has a great rest of the week. Thanks.
Okay.